County District Court is now in session. The Honorable John H. Guthmann now presiding.
Please have a seat. Call case.
Page 1, line 1, Association for Government Accountability versus Commissioner Myron Frans et al.
All right, appearances by counsel. First for the plaintiff.
Good morning, Your Honor. My name is Eric Cardall, representing the Association for Government Accountability with Ms. Deborah Ocean.
All right, morning.
Good morning, Your Honor. Tom Boddern on behalf of the Minnesota Senate Fiscal Services Office, and in fact representing the Minnesota Senate.
All right.
Jacob Campion, Assistant Attorney General on behalf of Commissioner Frans.
And Amy Schwartz with Lockwood Road, Thompson, Stabner, and Push on behalf of the House of Representatives.
All right, I think on this one we have three sides. I'll give everyone 10 to 15 minutes with time for rebuttal. Mr. Cardall?
Yes, Your Honor. May it please the Court, I'm just going to make a few points regarding clear public duty, then talk a little bit about the carryover statute raised in the Commissioner's brief, standing, ripeness, and then the companion case. With respect to the clear public duty, we're relying on the 2016 constitutional amendment and the accompanying statute that took legal effect. The statute 15A.0825 subdivision 7 states, by March 31 of each odd-numbered year, the council, that's the Legislative Salary Council, must prescribe salaries for legislatures to take effect July 1 of that year. July 1 is upon us, and it's an odd-number year. The Legislative Salary Council has issued its report, $45,000 per annum. Now, usually when you have an issue of statutory interpretation, Judge, and usually the specific statute trumps the general, and I'm in the situation that I'm arguing the early enacted specific statute trumps the later enacted general statute. That's not the case here. My statute is the latest enacted, and it's specific. So there is a duty for the government effective July 1 to pay those salaries. It's a constitutional duty, and I have a specific statute that supersedes these generally applicable statutes, but nonetheless, the generally applicable statutes that are listed on page 6 and 7 of my brief, that is 16A.012, 16A.17 subdivision 1, 16A.17 subdivision 5, 16A.17 subdivision 6, recognize the general duty of the state legislature to issue the warrants for legislative pay, and the general duty, specific legislative duty, of the commissioner to set up appropriation accounts, fund them, and redeem the warrants.
All right, and if we assume that's true, the legislature hasn't acted. The appropriation was vetoed, so the legislative work isn't done yet. So isn't this premature?
Moving to the ripeness issue. On ripeness, Your Honor, we have a few responses, some covered in our brief, but there's a concern here among my client that the public funding of legislative pay isn't going to occur on July 1st. The first hint we have of that that came in on Friday was a stipulation that the commissioner will not fund those appropriation accounts unless you sign the court order in the companion case.
All right, well, let's go there then. If that's the case, all of the public injury that you cite in your brief relates to the complete inability of the legislature to perform its functions. If this stipulation goes forward and the legislature continues to function at 2017 fiscal year levels, how has your client been injured?
For a moment, there's a big assumption that the court will sign the stipulation proffered.
Well, I'm asking you to answer the hypothetical question. If I do, you cite no injury to your organization related specifically to the difference between a $31,000 per year salary and a $45,000 per year salary.
Well, if the commissioner in any way appropriates the funds for the account and redeems the warrants prior to July 1, yes, there's no injury. If that's, but our point is with respect to, there's a big if there, will the court sign the stipulation in the second case? And the standards of law that the court must apply in that case include that have to be Hennepin County, the Uniform Declaratory Judgment Act cannot create a cause of action that does not otherwise exist. And the legislature doesn't have a private cause of action in that case. In the Eggenberger, this is the 8th Circuit, interpreting under the Minnesota Constitution, this is a 2016 case, there's no private cause of action for violations of the Minnesota Constitution.
So you would agree that if I sign an order consistent with Friday's stipulation in the other case, your case wouldn't have any current merit?
No, there's two issues there. What I said was if the commissioner pays, it puts the money into the appropriation account and redeems the warrants that are issued by the state legislative bodies, yeah, of course.
Which money? Money for salary at the 2017 fiscal year level, or money at the newly set level by the commission?
Well, if $45,000, that's our claim. That we're relying on the constitutional provision, the statutory text. The later enacted specific statute says that that this will take effect on July 1.
Right, but that gets back to my original question. If I order funding to continue at the 2017 level, effective July 1st, which would be the $31,000 per year salary, what harm has been done to your clients, and on what basis can you challenge the continuing operation of the legislature, which is the only injury you cite in your brief?
Judge, that's exactly what we're requesting.
I know you're requesting it, but you have to have an injury to your client to get it.
The injury is that the commissioner isn't going to do it without your court order.
No. What injury to your client for not having a $45,000 per year salary versus a $31,000 per year salary?
With respect, now we're getting to injury. That's a little different issue than ripeness. And so with respect to injury, Your Honor, there are some cases we'd like the court to look at. The 1888 case, Minnesota Supreme Court, State v. Weld, says in mandamus to enforce a purely public duty, any private person may move to be a realtor. And so that was a petition to compel the Register of Deeds auditor to keep the office at the county seat. In 2007, Olson v. State, the Minnesota Supreme Court, 742 Northwest 2nd, 681, said, as early as 1888, we hold that taxpayers may bring an action to compel county officers to perform their public duties.
You just argued in your brief that you don't have taxpayer standing. Are you changing your position and arguing that you do?
No, Your Honor. As the court knows, 586.02 is a remedial statute and must be construed broadly. And so the standard is not...
The construction of a statute doesn't deal with the issue of justiciability.
I'm trying to stick to this. I understand your point, if I may finish.
No, but you've contradicted yourself. You argue in your brief that you don't have taxpayer standing because that would require compelling the expenditure of money, and that the non-expenditure of money doesn't create standing. That's what your brief argues. Now you're citing a case that stands for the proposition that you do have taxpayer standing. So I need you to tell me whether you're claiming it or whether you're not claiming it.
Your Honor, there are two different forms of standing, as the court knows. In a quo warranto action, the court knows taxpayer standing is associated with the common law petition for writ of quo warranto. Here we have a remedial statute, 586.02, that says the writ shall issue on the information of the party beneficially interested. So beneficially interested, according to the Minnesota Supreme Court, beneficially interested the test, and if there's a public wrong, yes, in certain instances, taxpayers, residents, voters can bring the petition for writ of warranto. But my word, I just had one resolved by the Minnesota Court of Appeals just a couple weeks ago, Melissa Douglasville versus Stillwater School District. The writ of warranto, the petition for writ of warranto is a broad remedial statute, and there's a specific legislative standing conferred. If I were to interpret beneficially interested as strictly taxpayers, then a lot of proper petitions for writ of quo warranto wouldn't be brought. But yes, we're saying we're taxpayers, we're a group that is involved in the legislative process, and the court knows, it's in the record, that we've been fighting 36 county sheriffs and police chiefs for years to stop their legally unauthorized programs. These are programs the state attorney general, the state auditor, and the Waukesha County District Court have found to be legally unauthorized. And so it seems to me that the standing issue is resolved on justiciability. We also, I think, addressed that with respect to the clear legal duty with 586.02. My clients qualify as beneficial interest parties. We're providing information to the court. And the idea of the petition for writ of mandamus, of course, is, hey, court, here's some information. Someone's not doing their job. There's nothing wrong with that. There's nothing wrong with the state legislature saying public officials need to perform their specific, clear public duties. And here, the commissioner has conceded that the commissioner is not going to make those payments on July 1 without the court signing the other court order. And
What authority does the commissioner have to pay anybody without an appropriation from the legislature?
The constitutional amendment and the accompanying statute language I've already quoted, but I'll say it again. It says, by March 31 of each odd-numbered year, the council must prescribe salaries for legislatures to take effect July 1 of that year.
Isn't there a difference between prescribing a salary and appropriating money to pay the salary?
With respect to the there could be, except under the precedence of Matson, if it's a core function of the Minnesota Constitution, then, as Matson indicated, the funding shall occur absent the legislative appropriation. So Matson was a petition for the writ of quo warranto taken by the Minnesota Supreme Court. The Treasurer's Office was defunded with respect to critical functions. And here we have more language in the Constitution than Treasurer Matson did prescribing the constitutional mandate that this funding occur even absent a legislative appropriation. And further, we, as I mentioned, have a specific statute saying these salaries will take effect July 1 of that year. So what more can the people do? The people wanted to get legislative pay out of the political process. So they create a legislative salary subcouncil, makes a report in March of odd-numbered years, and then salaries are to take effect in July 1 of that year. And so it happens without, it becomes law, and then absent a legislative appropriation, it's constitutionally mandated. That's why we haven't sued the governor, to the issue you raised, is because we're dealing with the consequences of the governor's veto. That is, there's no legislative appropriation for legislative salaries. The people in 2016 voted for this constitutional amendment, and they expect their laws to be adhered to by all branches of the government. So if the people amend the Constitution and say, legislative pay council is going to make their report in March, and that's going to take effect in July, and then somehow the legislature and governor don't provide an appropriation, then we expect the court to say, well, it says to take effect. So legislators get paid. I mean, do we need any more text?
Right. At what level do they get paid? The emergency funding stipulation only provides for it to be paid at last year's level, this fiscal year ending on June 30th. Doesn't that take care of the damage to your client, and then let them figure it out? Why should the court get involved?
What's in error with respect to the injury aspect is in our view, is that we have Minnesota Supreme Court case law saying in purely public duties, when government officials, here the legislative branch and the executive branch, are not performing clearly public duties, a beneficially interested party can bring information to the court and say, hey, court, the other branches aren't doing their job. And that's what the statute says. And that's why the Minnesota Supreme Court in 1888, and as repeated throughout, that in certain cases with a purely public duty, taxpayers, other interested parties, residents, voters can come forward and say, hey, look, there's a problem. Now, the problem with the second lawsuit is they don't have a writ of mandamus claim. They haven't followed this procedure, and as I said, the Declaratory Judgment Act doesn't apply, so count one is out. The court doesn't have jurisdiction. The court can't sign that stipulation, can't accept that first count in the complaint for the same reasons you're giving me a hard time in this lawsuit. It's because the petition for writ of mandamus,
nothing personal.
the petition for writ of mandamus is intended to ensure that parties like the legislature and the governor don't participate in here with something that's not a clear public duty. And when we look at the stipulation, oh my word, they want you to enter the parties agree count one is right. Well, the court has no jurisdiction over count one of the complaint. It's a declaratory judgment action. As I said, the Minnesota Supreme Court and the U.S. Court of Appeals recently in the Eggenberger case said the Minnesota Constitution provides no private cause of action to sue the government. So there is no declaratory judgment action. Minnesota courts have said repeatedly the declaratory judgment action doesn't substitute for a private cause of action. The declaratory judgment action does not have an implied cause of action.
Right, but, and I don't want to get too much into the other lawsuit. The parties to the other lawsuit recognize the Minnesota Supreme Court decisions that indicate that the only way to challenge the constitutionality of a veto is through a declaratory judgment action. So I think we've been painted into that corner already.
Well, respectfully, I believe that that it's clear that the governor exercised a line item veto, and there's constitutional authority there. And so the court's saying is that somehow, is there a claim there? But if they fail to state a claim for relief, then that wouldn't be something to consider with respect to jurisdiction.
Let's finish with rightness because the clock is ticking. How do I know that these salaries aren't going to be paid at the higher level until someone writes a check and it isn't for that amount?
Well, we know that on Friday, June 23rd, the commissioner submitted a stipulation saying they wouldn't pay any amount, basically that they're only going to pay that amount of money that they're going to pay if the court signs it.
No, they want me to order continued funding at 2017 fiscal year levels. It doesn't say anything about what they're going to do with that money.
And that's true, and so that still doesn't satisfy our concern. I guess secondly, the point would be with respect to the earlier end of the fiscal biennium cases, 2005, 2011, former Chief Judge Johnson and former Chief Judge Guerin took those cases, and they were filed prior to the end of the fiscal biennium on June 30th, and the reason was to assure continuous funding.
Right.
Okay. If I may, one last point, and I know I'm running up against it, but on 16A.281, that's the carryover statute, there are a couple issues of statutory interpretation that the court should be aware of because of the position the commissioner's taken. Our position is 16A.28 governs, but not in the way the commissioner argues. The title of the statute is Appropriations to Legislature, so the sides agree that that statute applies to the situation regarding carryovers. The first part says year to year within a fiscal biennium there can be carryover, but the key issue is two sentences. The first one is an unexpended balance not carried forward and remaining unexpended and unencumbered at the end of a biennium lapses and shall be returned to the fund from which appropriated. So that means that the complaint and the stipulation are wrong because on July 1, those funds that aren't used as so-called carryover is going to lapse into the general fund. It's no longer the state legislatures. And there is a but, and this is the point that the commissioner's making, but here they argue too far. The second sentence is, balances may be carried forward into the next biennium and credited to special accounts to be used only as follows. So here's where the dispute arises. 1, for non-recurring expenditures on investments that enhance efficiency or improve effectiveness. Under Minnesota Statute 645.081, technical words are given their special meaning. Non-recurring expenditures would not cover legislative pay. Point 2, to pay expenses associated with sessions, interim activities, public hearings, or other public outreach efforts and related activities. Again, 645.081 says technical words are given their special meaning. It says to pay expenses. As we've shown through the statutes and through the rules adopted by the resolutions adopted by the respective legislative bodies' rules committees, expenses are different than legislative pay. That's a technical word that has a special meaning, expenses. Further, 3 says to pay severance costs of involuntary terminations. As the court knows, 645.15 says a law is to be construed to give effect to every provision. So if somehow the court were to find, as the commissioner encourages, that expenses cover legislative pay, we believe it would make 3 surplusage, because it says to pay severance costs of involuntary terminations. So if it related to payroll, if expenses include payroll, why would they have included 3? So the carryover statute is no comfort to the commissioner, no comfort to the governor or the legislature, and that's the reason why the court can't sign the court or the stipulation in the next case, because the court can't sign an order authorizing an illegality. The court needs to sign court orders that enforce the law. That's what's important.
So your position is that the 2001, 2005, and 2011 orders providing for the continuing funding of state government after July 1st were all invalid?
The cases ended prior the Ramsey County District Court proceedings in the end of the fiscal biennium cases in the previous years, one by Chief Judge Guerin, one by Chief Judge Johnson. They were valid to the extent that no appeals were ever heard. I mean, they never resolved.
Legally invalid.
Right.
Is that your position?
My client's prior positions, I represented in 2005, after 2005, 33 Republican and Democratic legislators who had a problem with the Ramsey County District Court issuing orders to disperse funds in absence of a legislative appropriation.
Okay.
But they would have made an exception for a narrow Matson-like case. And so, yes, we think that those were not proper, and that's why my clients in the previous cases appealed. The position I've taken in the court today is not inconsistent. It's based on a narrow reading of Matson that Attorney General Hatch and Attorney General Swanson took in the 2005 and 2011 cases, respectively. Thank you, Your Honor.
Thank you. We'll hear next from counsel for Commissioner Frans.
Thank you, Your Honor. The petition should be dismissed for 3 reasons. 1, this case is not ripe. 2, the petitioners don't have standing. And 3, mandamus is not an appropriate procedural vehicle for the relief they're requesting. As to ripeness, both the House and Senate have substantial funds available to pay for things like salaries beyond July 1st. And so the case...
We just heard an argument that Chapter 16A doesn't allow you to use the money for salaries.
I don't think that's true. It talks about pay expenses associated with sessions, interim activities, public hearings, and other public outreach efforts and related activities. And that is the harm that they are claiming, is that if the legislators aren't paid their salaries, they won't be able to meet with their organization or hold hearings to address issues that they want to bring before the legislature. So that would be covered within that statute.
Yeah, but you just conflated 2 things. You conflated the items you read with salary. I don't think that it represents Mr. Cardall's argument quite accurately. He's saying that the items you read don't include salaries, so he's still left, his client is still left hanging.
Well, if the legislator sends over checks for salaries to be paid for with the appropriations that they have left over from fiscal year 2017 and with their carry forward balance, the commissioner would sign those checks. And the commissioner believes it's consistent with the law.
Okay.
So because there is substantial money still available to pay for salaries, this matter isn't ripe. And it's also not ripe because to issue a writ of mandamus, the petitioner needs to demonstrate that there is a public duty that has not been performed. And to date, that hasn't occurred. We know from the filings in the other case that the Senate is going to continue to operate till July 28th. And that the House until September, and that's regardless of whether the court signs that stipulation that's been referenced.
Well, there have been at least one of the houses has made some announcements that there's no intention to pay the higher salary. We've seen action taken before July 1st on other occasions based on findings that the issue is ripe for decision, even though you don't truly know until after July 1st whether the money is there or the action is going to take place. How do you reconcile those past cases with what's happening here?
Well, if it's true that one of the houses or one of the chambers doesn't plan to pay that, I think that's a question for them when they present. Commissioner Frans doesn't take a position on $31,000 versus $45,000.
Okay.
They have funds appropriated, and if they prepare payroll and send over the checks, he will sign them.
All right?
As to standing, again, it requires an injury. This is similar to ripeness, that there hasn't been an injury that has occurred yet. And I also add that the injury that they're alleging is speculative. It's not just that legislators won't be paid, but they're speculating about how legislators will act if they aren't paid. They're saying legislatures won't meet with us or address our concerns, and we just don't know today whether that will occur. And so because that injury is speculative, they don't have standing for this case.
Do you agree with Mr. Cardall's argument that the requirement of individual injury apart from the public as a whole is a special standing rule that only applies to quo warranto claims? Or is that a broader rule of standing that applies to anybody who brings a claim?
Yes, when you bring standing, there's typically...
You can't just say yes, because I said one or the other.
I'm sorry. I don't agree. The commissioner does not agree with that position. Standing requires a harm that is specific to the organization that is coming before the court, and it needs to be distinct from a harm to the general public. And so they are not alleging a harm that is distinct from the general public. And they also do not meet the requirements for organizational standing. Organizations can sue for injuries to themselves or to their members. But to sue on behalf of one of your members, the Court of Appeals has said you need to identify the member and set forth facts sufficient for the member to have standing if they had brought it themselves. None of their submissions identify a member or assert any harm on behalf of a member. And as to the standing as an entity, the Supreme Court has said one of the key considerations is if you deny standing to the organization, would that prevent anyone from being able to sue? And that's not the case here. Legislators would be potential plaintiffs to sue if they feel they're wrongfully being denied salary increases. So for all these reasons, this organization doesn't have standing for the relief requested. And as to the statutory criteria, again, it talks about a duty that's not being performed. We haven't gotten there yet. It talks about a specific injury to someone who's beneficially interested. We don't have a specific injury. And it also says that no other adequate relief is available. And that's not the case here. Writ of mandamus is not an appropriate procedural remedy. This case could be brought as a civil action seeking injunctive relief or under the Declaratory Judgment Act. And the cases he referred to that talk about causes of action under the Constitution, what they say is that there is no equivalent to Section 1983, which is federal law that allows people to sue for damages for violations of their constitutional rights, but courts frequently address claims under the Minnesota Constitution when the relief sought is equitable. And so that is an available remedy such that a writ of mandamus is inappropriate. So for all those reasons, the Commissioner believes that the petition should be dismissed. And unless the Court has further questions, I will sit down.
All right, thank you.
Thank you, Your Honor.
Let's hear from the House. Morning.
Good morning, Your Honor. There's one thing that all of the parties agree on, and that's to have standing to seek mandamus relief, a petitioner must prove three things. An official has failed to perform an additional duty clearly imposed by law. The petitioner was specifically injured by the failure, and there is no other adequate legal remedy. The AGA does not have standing because it cannot prove any of these three prongs at all. First, the AGA has not shown that an official has failed to perform a duty clearly imposed by law. Even under their scenario, there is no payment that is due until July 1st. Of course, it is not July 1st yet, so there is not a current failure to perform any duty clearly imposed by law, even under their hypothetical scenario.
As of July 1st, is there a duty to pay members of the House $45,000 a year under the Minnesota Constitution and the enabling legislation?
The Speaker of the House has made public statements that he does not intend to, although of course I don't know what his ultimate goal will be. He believes that that without an appropriation for the funds, they cannot be paid at the $45,000 level, but they can continue to be paid at the $31,140 level.
And who would have standing to challenge that?
Legislators themselves.
No one else?
Well, anybody else who who's specifically injured by that practice, of course, the group that immediately jumps to mind would be any legislator that is not paid that amount.
Right.
There may be other groups as well, but I think they're the most obvious group, which is a large pool of people that would have standing to sue. I wouldn't fail for the reasons that we're talking about here.
What about any other non-legislator citizens?
If they should demonstrate that they suffered a specific injury, potentially. But of course, that's the second prong of the test, and it's really where the AGA falls down in their claim. I think it's an insurmountable hurdle for them. To be specifically injured, a party must show a discrete and particularized injury that is different from other citizens generally. The AGA claims that it's specifically injured because its members are taxpayers who have lobbied the legislature in the past and may lobby the legislature in the future. The AGA claims that if legislators are not paid, legislators would be less available to meet with them, that legislative staff would not be as available to take telephone calls and the like.
Mr. Cardall argued that the particularized injury requirement was unique to quo warranto and did not apply to his type of standing, organizational standing.
I believe that's incorrect.
Based on what?
586.02 requires that you be a beneficially interested party. That's been deemed to mean this injury in fact test for standing. And the cases which reference that are cited in the briefing. But, there is, I think, Breza v. City of Minnetrista and Northern States Power Company versus Minnesota Met Council are two of the lead cases which talk about that requirement and what it means. So essentially, mandamus relief is, of course, extraordinary relief. You have the first prong, which is that there's an official duty that's been filled. The second prong, which is a generalized standing test, the injury in fact test. And the third point being that because it's an extraordinary remedy, no other legal relief is available. So the AGA claims that it's specifically injured because its members are taxpayers and voters who've lobbied the legislature in the past and may lobby the legislature in the future. The AGA claims that if legislators are not paid, they'd be less available, but that's not a specific injury because it's the same purported injury as would be suffered by millions of other Minnesotans. And Minnesota law is clear that taxpayer suits should be dismissed unless there is an injury peculiar to the individual taxpayer who is bringing suit. The AGA's argument essentially seeks to do away with the rule against taxpayer standing, and that's not the law. So in our briefing, and I think as Your Honor asked Mr. Cardall, there is an exception to taxpayer standing based on the illegal disbursement of funds. In the briefing, and we argued, of course, that there was no illegal disbursement of funds. The whole point is that they're claiming that we were not properly dispersing funds.
So that would be, can the non-disbursement of funds be the same as an improper disbursement of funds?
And Minnesota courts have already ruled on that. Olson v. State is the instructive case on that point. The idea is that non-expenditure of funds does not provide taxpayer standing. The reason why expenditure of funds gives you taxpayer standings is because there might be an increased tax burden on taxpayers if their funds are illegally spent and dispersed, whereas that issue doesn't exist for the non-expenditure of funds. I believe that's the rationale in the cases. Moreover, the injury itself is a speculative future one. Given the carry-forward funding and the recent stipulation to extend the funding for 90 days, and I know that's unsigned, it's unclear that the AGA will suffer any injury, let alone a specific one. As the court correctly pointed out, there is no injury that the AGA will suffer as a result of payment at the 2017 levels versus the 2018 levels. So, for example, I think the briefing goes on and sort of lists a parade of horribles about what would happen if the legislature shut down, if no staff was available, if legislators weren't paid at all. But that's not really what the dialogue is right now. Right now, it's a discussion of $31,140 versus $45,000, not $45,000 versus zero, which is how I think their briefing is set up.
So if you were representing an individual House member who was worried about the public statements of the speaker and afraid that they weren't going to get their salary increase on July 1st and brought them here to court to make that claim, you wouldn't have any argument against the fact that there's no ripeness as of now, correct?
Well, I think
you'd wait until after July 1st.
I'd wait till July 2nd, if in that case, but in your hypothetical. But no, an actual legislator who would argue that they should be paid at $45,000 versus $31,140 would be specifically injured. They would meet that prong of the test.
Not now, only then.
Yes.
Okay.
Third, the AGA must show that there is no other plain, speedy, or adequate remedy in the ordinary course of law. The AGA argues that while declaratory and injunctive relief may be available to other parties, those forms of relief are not available to the AGA, and thus the AGA should be afforded mandamus relief. The AGA has it backwards. Mandamus relief is an extraordinary form of relief. There are other forms of relief like declaratory judgment, injunctive relief, claims for back pay that are more appropriate and are available to parties with standing. If legislators, as we just discussed, feel that they are not properly paid after July 1st, the legislators themselves can directly sue. The fact that the AGA is not entitled to any of the normal forms of relief is not evidence that the AGA is entitled to the extraordinary remedy of mandamus relief. Rather, it demonstrates that the AGA lacks standing.
So if there's a remedy available to someone else, you can't bring a mandamus claim.
Yes, you shouldn't be entitled to say, well, I haven't met the standing test, but I have no specific injury. Somebody else is a better party to sue, but nonetheless, I'm going to step in and seek an extraordinary form of relief. That seems inappropriate. Instead, the legislators are the ones who, to the extent they have a claim or a claim exists, they're the ones who are directly injured. They would have standing to bring a claim.
So legislators wouldn't be able to bring a mandamus claim either. They would have to sue for back pay.
Well, I think they could sue for declaratory judgment or injunctive relief and back pay is what I would generally imagine a lawsuit would look like.
But not mandamus.
Well, they of course could sue for mandamus relief. I just think the other forms would be preferable and more in the ordinary course, like any other back pay claim.
Right, but if I take you at the word of your argument, not even a legislator would be able to bring a mandamus action because they have other available means besides mandamus to accomplish the same outcome.
Yes, I think a legislator would have difficulty with prong 3 of the test.
Okay.
Yes. With respect to ripeness, it goes without saying that courts can only resolve claims that are ripe. A claim is ripe if there is a direct and imminent injury. Hypothetical issues that do not exist in the present and may only exist in the future are not justiciable. Here, there's no direct and imminent injury. There is carry-forward funding that can be used to pay legislative pay. There is potentially a stipulation to extend the legislative functions for 90 days. The injury the AGA complains of is a complete elimination of funding. It's not a reduction in funding, and I don't see any evidence or any reason to think that if legislators were paid their old rate of pay, that they and their staff would disappear from the face of the earth. I mean, that seems a bit extraordinary. Last but not least, Governor Dayton is an indispensable party. you know, we think that the case should be dismissed because it lacks standing and it's not ripe. But if the case does move forward, Governor Dayton is a necessary party. The AGA claims that they're not challenging the constitutional authority of Governor Dayton to issue a line item veto, but they're just seeking to avoid the consequences of the veto. Of course, making salary payments would in effect limit the effectiveness of the veto, which is supposed to, or was at least I think intended to, eliminate legislator pay, among other things. So under Rule 19.01, a party who has an interest in the subject matter of the action must be joined if exclusion of the party may lead to inconsistent obligations. It seems to me that Governor Dayton would have an interest in an indirect challenge to the effectiveness of his veto, even if they're not framing it as a direct constitutional challenge.
All right.
Thank you, Your Honor.
Does the Senate want to be heard? Did you file a separate brief?
I will be brief, as the Senate's papers suggest. Once again, and if there is...
Your time's up then.
That suits me. But, Your Honor, once again, I'm Tom Botter. I'm with the Office of Senate Counsel Research and Fiscal Analysis, and I'm representing the Senate in this matter only. As the papers filed by the Senate suggest, of course, the Senate concurs in the arguments made by the House. There is another small point that I do want to make, and it is raised in the papers we filed. Mr. Cardell attempted to serve the Senate Fiscal Services Office, which is an administrative entity of the Senate. The Senate is the official entity and should properly be named as the party in this instance. That, however, is a minor point. I think, obviously, it's for you to ask counsel for the House, but they may concur with regard to the entity named on behalf of the House. So the Senate would respectfully request that the court dismiss the petition for the writ of mandamus and rather deny the petition and proceed accordingly. If there is any additional time, the Senate can concede. If you can manage the time as you see fit, of course, but we would concede that to the House.
Right. Well, the House is done. Mr. Cardell gets some rebuttal. Thank you.
Just a few points, Judge. I just want to remind the court, because I've sat through a lot of arguments by my friends representing the government in this case and other cases, that the first thing the court has to do is decide what the law is. In other words, if you're going to determine whether there's a violation of a clear duty, we need to determine what the law is. So what is required on July 1st? Our position is that the later enacted specific constitutional provision and statute say that the report in March shall be the pay on July 1. So, okay, so the court sits there and says, okay, my first job is to decide what the law is. Well, that's the law, and they don't even have a later enacted general statute that they're arguing amends or implicitly repeals the later enacted specific statute constitutional amendment.
Is there any scenario under which the legislature could decide not to appropriate the money to pay the prescribed salary?
Of course. The legislature has the freedom to legislate the appropriation or not. But in absence of the legislative appropriation, anyone can come here and say, anyone who's beneficially interested can come here and say, we passed a constitutional amendment, there's an accompanying statute, that takes effect July 1, $45,000 per annum, pay, and then the court would issue the order in absence of legislative appropriation. Now, the writ itself...
Well, hold on, because you just confused me. If the legislature has the authority to appropriate less than the prescribed salary, then why would the court come in and step in when they haven't done anything? It's been vetoed. There isn't an appropriation at all for anything. So if they have the authority to appropriate less, why wouldn't they have the authority to appropriate nothing?
It's my failure to communicate accurately. Okay. So the question is, can the legislature do what the legislature is going to do because the legislature meets and enacts laws and doesn't enact laws. Yes, but it can create, by its lack of legislative appropriation for the $45,000 and the governor signing that, a situation where my clients identify, look, there isn't the legislative appropriation to meet the $45,000. We're here to saying that's what the 2016 constitutional amendment and accompanying statute mean. So the court has to declare what the law is. So we come here with a later enacted specific constitutional provision and statute saying $45,000.
Well, wouldn't you agree that before the constitutional amendment, the legislature had the authority to both prescribe and appropriate legislative salaries? And now, based on the constitutional amendment, those two functions have been separated. A commission prescribes, but the legislature still has the authority to appropriate. So if I follow your rationale, wouldn't we be giving the commission both the authority to appropriate and prescribe? Who needs the legislature?
Right.
Just run to the court and have them pay it if the legislature doesn't do it.
I appreciate, this is exactly what I requested the court do, look at what the law is. So Minnesota statute 15A.825, this is later enacted in specific. By March 31 of each odd-numbered year, the council must prescribe salaries for legislatures to take effect July 1 of that year. So to take effect July 1 of that year, that's what the court has to ponder then. Under the court scenario, when it says when the legislature passes a law implementing the constitutional amendment for the Legislative Salary Council and says to take effect July 1 of that year, is that then saying that in absence of a legislative appropriation, a citizen can come to the court and ask for a writ of mandamus so the full $45,000 is paid? And so in absence of a legislative appropriation, then we come and say, well, look, we want Minnesota statute 15A.825 subdivision 7, which is part of the constitutional amendment scheme, to be implemented by the court. So imagine...
Well, then I would just declare, yes, the salary is $45,000. Now figure out a way to getting it. Because all the commission does is prescribe the salary effective on a certain date.
Well,
so that's the salary.
That's not exactly the words, Judge. It says must prescribe salaries for legislators to take effect July 1 of that year.
Right.
So that would mean that in our point of view, and reading and giving a meaning to each of those words in the later enacted specific statute, that when the Legislative Salary Council makes its report, that shall be the salaries July 1 of that year to take effect.
Right. That is the salary, and that takes effect on that date. But does that supplant the legislature's sole constitutional right to appropriate money?
We've crossed that threshold before in the Mattson case. So the Minnesota Supreme Court said in the Mattson case that if the legislature defunds an executive official, the treasurer, in absence of those appropriations, the court order will issue, so those necessary and core functions are funded anyway.
Right, but you've now, again, conflated two different issues. Whether the core functions of government are funded or whether a pay increase is funded. So if I were to grant the emergency funding that's been requested, everything would continue as it's been continuing, at least for the next 3 months. So
the people expect more from the court. The people enacted a constitutional amendment with this accompanying statute that was enacted before the adoption of the constitutional amendment became effective after the constitutional amendment was adopted. And the people expect that this language to take effect July 1 of that year to be honored by the court.
So you would argue then that the commission has now replaced the legislature, and the commission both sets the salary and appropriates the money for the salary?
No, of course, my position is more nuanced than that. The position is, as set up in this case, that in absence of a legislative appropriation, in this case, the governor and the legislature failed to appropriate for legislative pay. So we're coming to the court and saying, court, based on our constitutional provision and statutory provision, which is later enacted and specific, that there's a clear legal duty to pay the $45,000 per annum starting July 1st.
So the nuance is that the court appropriates the money.
Well, the Mattson case, as I mentioned, says that in absence of legislative appropriations, a court order will issue to meet the requirements of the constitutional mandate regarding, in that case, the executive office.
Right, but in the Mattson case, that dealt with the core functions of the office. So do you take the position that a pay increase is a core function of the legislature's office?
We take the position that the people came together and solemnly voted for a constitutional amendment, and it passed. And we believe the government, at the very least, when the people speak, should adhere to the law. And the law is the Legislative Pay Council makes a report in March, and the statute says to take effect July 1. And what could be more clear and public than that? Now, with respect to the mess we're in, that's not the AGA's creating. That is that where were the lawyers when this was being negotiated between the legislature and the governor? You don't do the lawyering after the fact. You do the lawyering before. Everyone should have known that legislative pay is part of
If that was true, there wouldn't be a legal profession at all.
All right, I'll take that to move on to the next point. All right, just a couple things then. With respect to standing, this ends up being important, I think, petition for writ of mandamus case, because the government's really coming hard at us with respect to beneficial interests. As the court knows, this is something that's commonly used. In fact, legislators rely on the petition for writ of mandamus to set up certain situations in court. The court, with its experience, would know that inverse condemnation, the statutes rely on 586.02, and in the ordinary course, the petition for writ of mandamus is used to initiate inverse condemnation action. There are other actions, I can't think of them right now. And also, it's a remedial statute. It was intended to plug a hole. And so when it says beneficially interested people bring information to the court regarding compelling a public official to do a public duty, the legislature meant it. Then, of course, the series of cases, State v. Weld, which I read the quote from, Olson v. State, since we've been allowing taxpayers to bring petition for writ of mandamus cases since 1888, and then Skanoka v. St. Louis County, 281 Northwest 2nd, 659, it's a 1979 case, where a plaintiff was a resident and taxpayer in a county and was challenging the government not enforcing zoning ordinances. And as I mentioned...
but there was particularized injury in that case because that citizen was affected by the zoning ordinance, unlike people a mile away who weren't.
Well, how about State v. Weld? Okay, county auditor, register of deeds, you got out of your office in the county seat. Now, how did the taxpayer in that case? I suppose the government's arguing, my friends would argue, well, it's affecting everyone that he wants to have the office elsewhere.
I'll look at that case and we'll see if standing law has changed since 1888.
Okay, in the 2007 case I want to mention, because you should read that one as well, because it says, it's a Minnesota Supreme Court case, it says, since 1888, we've been recognizing taxpayers as being able to bring claims under 586.02. So if we don't want to discount the case, because in the Minnesota Supreme Court 2007 said that the case basically carried forward. And a lot of times when they're referring to cases, they're borrowing cases that aren't under 586.02 for standing requirements. Also, they're ignoring the fact that the court has conjoined public injury, that especially injures the party. And so you'd want to look at the public nature, how public is it, and then look at the injury. And I think our case perfectly fits within the standing requirements under 586.02. Thank you.
All right, thank you. We'll take a brief recess before calling the next case.